Well, hi there. Warm welcome. You're watching Blueprint Explosive Exclusive and I'm Meghna Deka. Viewers, on the 7th of November, this film, Haq, is going to be released across India. It is not just an ordinary story. It's not just an ordinary film. It's a reflection of a landmark moment in India's legal and societal history. A fight for gender justice in India. Even before the release, this film has ignited a fierce debate across the entire nation. A debate around personal laws, a debate around equality and the constitution. Just because you are a Muslim woman in this movie, questions are being raised. Are you not going to be considered an Indian citizen? What are your rights? What are your privileges? What are your duties? That is the conversation that has been sparked off, because it is hugely relevant in a day and age, even as we speak. And to explain what I want to begin with this question: what should take precedence if it is a fight between a constitutional right and religious freedom? Which one will reign supreme? We've got the answer to this question today from the Kerala High Court itself. Well, the Kerala High Court was hearing a case of a Muslim man's second marriage. He wanted to get it registered, but his petition was dismissed. So it's important for us to understand what really was said while the High Court heard this Muslim man's petition. He said he had the right to get his second marriage registered. While hearing the petition, Justice P.V. Krishnan made some very, very interesting observations. It's important that one by one, we tell you what the court has said. And this is verbatim what the Kerala High Court has said. That the Muslim man must inform his first wife before he registers the second marriage. High Court also said the first wife must be heard before registering the second marriage. It also said that 99.99% of women, of Muslim women, will be against their husband's second marriage. The court has also said that the High Court cannot ignore the feelings of the first wife, that it can't ignore constitutional rights in the name of religion. Now, this was an order which has been delivered by the High Court. And it's important for us to understand why all of this is so very significant. What does it say? Essentially, that if there's a first wife who objects to the marriage, to the second marriage of a husband, then that marriage cannot be registered. The order also says that the registrar himself or herself must refrain from registering the second marriage sans a permission from the first wife. Also, that he or she, the registrar, must refer the parties to a competent civil court. But in civil court, what happens? This is interesting. The civil court will establish the validity of the second marriage under the Muslim personal law. That is what the High Court has said. Now, all of this is very interesting because we must explain to you what really was this plea about. Well, this was a plea which was filed by a 44-year-old man who already had 2 children from the first marriage, and he was relying on the Muslim personal law to justify his second marriage. His claim was that Muslim personal law allows 4 wives to a Muslim man. This plea has been dismissed. He also claims that the registrar is bound to register his second marriage and cannot refuse to do so. This plea, as I was telling you, has been dismissed in the Kerala High Court. Well, the Kerala High Court has drawn what many can call the Lakshman Rekha, the red line for Muslim men. The fact is, as per the red line which has been drawn by the Kerala High Court, they have said that while he is married, he needs the permission of his first wife to get married for the second time. Also, that in case the man has already divorced his wife, or if there is a case of talaq, in that case, permission of the first wife is not needed. It's only required if the marriage is undergoing, if it is existing. Well, the court, interestingly, has also referred to the Kerala Registration of Marriages Rule of 2008. And here's what the rule book says. Well, the rule book says that the registration of marriage is a legal requirement. Also, that before registering the second marriage, a notice must be sent to the first wife, which is mandatory, which is why the registrar in this case had refused to register the marriage. So what happened after that? Well, the petitioner kept on citing his rights, which were given to him by his religion. The court then quoted the Holy Quran itself. And this is the most important bit, because the court has upheld the Holy Quran, has quoted the Holy Quran itself. In fact, what exactly it is that they have said? They have said that as per, this is the Kerala High Court, which has quoted the Holy Quran and has said about the Quran, saying, as per the Quran, explicit consent of the first wife is not needed. But as per the Quran itself, spirit and intention of Quran is that of monogamy and not of polygamy. That as per the Quran, polygamy only is an exception. The High Court has also said that as per the Quran, you can marry more than once, up to 4 wives, but it is allowed only and only if the man can do justice and provide for all his wives. This is very important. Also, you have Justice P.V. Kunhi Krishnan, who says that as per the Quran, you must uphold justice, fairness, and transparency, saying that that is intrinsic to the Quran as well. So the message was loud and clear. Samvidhan is above religion. The first wife cannot be a silent spectator, that the constitutional rights cannot be ignored in the name of religious freedom. Gender equality is not a woman's issue, it is a human issue. In fact, very categorically, the High Court has observed, and I'm going to take you through the observation, that religion is secondary, constitutional rights are supreme. Mind these words, I'm going to read it out again because it's very important that we look at the first observation that we are going to show you again. That religion is secondary, constitutional rights are supreme. Let this sink in. It also then goes on to say that the law of the land will prevail and will be upheld. High Court also said that fundamental principle of natural justice must prevail. Now viewers, this happened, remember, in 2025. It shows how relevant a film like Haq is even today. It depicts the landmark ruling of 1985, 30 years back. This is what had, 40 years back, I beg your pardon, this is what had happened. It had become a crucial moment in the history of Muslim women's rights in India. It granted them right to maintenance under Section 125 of the CRPC. This also, at that time, had led to massive backlash. And then you had Prime Minister Rajiv Gandhi, who enacted the Muslim Women Protection of Rights on Divorce Act of 1986. It restricted alimony for only 90 days or the iddat period for divorced women. Then its constitutional validity itself was challenged before the Supreme Court in the Daniel Latif versus Union of India case in 2001. Well, the case ensured that women get free, fair, and reasonable assistance to live with dignity. The next step in gender justice came in 2014. The Supreme Court delivered another key judgment in Shamim Bano versus Ashraf Khan case. Here the court held that Muslim women were entitled to maintenance even after divorce. Then came another ruling. This one came in 2017, and the Supreme Court declared the practice of triple talaq as being unconstitutional and as being invalid. Well, a lot has been done in the last 40 years, but a lot still remains to be done. And what is the case in Kerala High Court has really shown us that Kerala has done it. But the big question is, will this pattern, this template that Kerala High Court has shown be followed across India? Let's in fact go across to our panelists Today, joining us on the show, we have Dr. Zeenat Shaukat Ali, an Islamic scholar. Also, Ahmed Ayaz is joining us, a political analyst. I'm going to come across to you first, Dr. Shaukat Ali, because it's important for us to understand what do you make of it. Since you are an Islamic scholar, I'm going to ask for you, what do you make of the Kerala High Court's order that the first wife must give an approval, otherwise you cannot register your second marriage? Is it as per what the Quran would uphold?
I agree with the judgment. Thank you for inviting me to the show. It's an important thing that I should say that the Kerala High Court has done the completely right thing. It has shown adl and it has shown justice. It has shown balance. And I would like to point out that some Muslim majority countries, even some non-Muslim majority countries with large Muslim populations have passed laws that make a first wife's consent at least her being heard before a second marriage takes place. And you have the example of Pakistan, which is a redundant country, but somehow in 1961 they have passed an excellent law and which mandates that, you know, when a marriage takes place, the consent of the first wife is essential. Also, there is an arbitration council whose consent also is essential. And if anything is violated, then there is a penalty of either imprisonment or a fine or both. So I think what the Kerala High Court has done is in consonance with justice that the Quran is giving you. And if I may claim your indulgence just for the minute, I would like to point out that polygamy itself is a restricted. It is a restrictive and not a permissive ordinance. Like has been pointed out, it is only for exceptional cases when it was permitted because it was revealed at wartime when women were being widowed. And in the same Surah Nisa, in Surah 4, there is a verse 129. You know, verse 4 of Surah number 4, verse number 3 speaks about 2, 3, or 4 marriages, but and equality between them and other things. But 4:21 clearly clear, and I'm quoting the Quran. You can never be able to be fair and just as between women, even if it is your ardent desire. So it is paving the road to monogamy. So here what happens is that adl or justice is considered to be the first balance, and I think that justice to genders was a priority of Prophet Muhammad, may be peace upon him. He gave women a huge lot of rights.
Absolutely.
You know, which somehow or the other are overlooked and not practiced.
So the basic principles, in fact, let me take that point across to Ahmed Ayaz. Would you agree with Dr. Ali that the basic principle, the basic tenets of what the Constitution is saying is also in consonance with what the Quran is saying? You cannot deny a woman of her basic dignity, her rights, as well as equality.
No, it's not only about the Constitution, but the Quran itself has been very rightful towards the woman, particularly in Islam. And I think Shaukat Zeenat Ali will agree with me that it's not out of a pleasure that one can go for more than one marriage in Islam. So it is because of certain conditions, certain circumstances where we call it a social responsibility, when after Battle of Ahad, that many men were killed and then many were rendered widows, and then to see that that as a social responsibility, the widows are married, but not as a matter of pleasure. But while agreeing to these points, I must ask, can she ever quote anywhere, despite there must be lot many judgments from time to time, but can she anyway quote any Quranic reference where it is said that that the permission for a second marriage is required from the first woman?
Okay, important point. Let me take that across. That's something that even the High Court judge has said. Shaukat Ali ji, the fact that you have even the High Court saying it doesn't explicitly say that, but despite that, that is the conflict which is coming in. When there is a conflict between what religion permits and what the Constitution permits, what takes precedence? It is the Constitution, right?
But then again it goes then in that
let
case,
Dr. Zeenat Shaukat Ali answer.
It violates the constitution itself.
Let Dr. Zeenat Shaukat Ali answer. She is after all a scholar herself. Islamic scholar herself.
Yes, I'd like to answer, the panelists, my distinguished panelists who has brought up this issue. The Quran believes in a principle. It does not go into the detailing. And the principle is that of justice and balance. And when this law was brought about in Pakistan, there were 40 ulama, people who were consulted when these laws were made, and a questionnaire was rotated. And eventually, this law which came into existence because of the debates and the arguments. So to say that, if in the first instance, polygamy itself, I would say, is not permissible at all with this verse 4, which I have quoted to you for Surah number 4, verse number 29, that you can never be able to be fair between your women, even if it is your ardent desire.
Yes.
So what does it mean? So you see, the Quran is explaining.
How is that fair? How is that fair? Very important. Ahmed Ayaz, you have your answer. How is it fair? Would you agree that the Quran says that you must be fair, there must be balance? How is it fair if without even telling your first wife, you bring in a second wife or a third wife or a fourth wife without taking her permission? How is it fair, Ahmed Ayaz?
Of course.
Patriarchy.
No, wait, this is a matter of interpretation you are making, but the Quran is very clear that the permission may not be needed.
But does the Quran not talk about equality, about balance?
And you'll have to provide justice to all. And now that when we come to today's judgment about the Kerala High Court, I'm afraid that it may not run against the Constitution itself, because the Constitution permits the religious freedom. When the religious does not stop you or wants you to take a permission from
Constitution also talks about rights and freedom and equality.
Second wife.
Ahmed Ayaz, if you read the Constitution, it will also talk about the rights.
That's okay.
Article 14 goes on to say that.
But here it's very clear. It's very clear.
Article 14, please read that.
That the permission may not be needed, but you need to be fair. No. Yeah, that's okay.
It is about fairness. I agree with you. Ahmed Ayaz, it is about fair. I'm asking you a straight question again. How is it fair for the first wife, for her husband, to bring in a second wife without even informing her, without taking her consent? Is that fair?
No. No, that may be a matter. That may be a matter.
No, it's a yes or no question.
It or not, but as long
it's
as
yes or no question.
As long as Quran is concerned, no. As long as
It was very
no. That may be a different thing. That whether you like it or not. But if we go by the Quran, then the Quran is very clear about it.
What does the Quran say? That there should be fairness, there should be balance.
Clear about the justice, clear about adl, clear about the balance. But here we are imbalancing, a situation.
Ahmed Ayaz, does Quran talk about balance?
There's a point made by the Zeenat Shaukat Ali. That's very clear.
You've read the Quran. You've read the Quran.
Fairness.
Have you read the Quran, Ahmed Ayaz? Does it talk about balance?
No, wait a bit.
I'm talking about the Quran and
yeah, sure.
It talks about balance.
No, wait a bit. There are two issues. One, that you have to be fair, and unless you are fair, you need not to marry. Second is whether permission is required or not. Well, as long as permission is concerned, it is not required.
Is it fair, Ahmed Ayaz?
If you cannot
let me ask you.
Let
me ask you for your personal opinion, because there are two different Islamic scholars, both of them disagreeing with each other. Do you think it's fair for a woman to be told that her husband is remarrying and she doesn't even know about it? That her permission has not been sought? Is the Kerala High Court's right in saying 99.99 women will not want their husband to remarry?
Again,
may I answer?
Again, my distinguished panel friend will appreciate that we cannot overrule. Our opinions cannot overrule the Quran.
You're not answering that. Zeenat Shaukat Ali, final words. I'm completely out of time. Zeenat Shaukat Ali.
The point is this: that when my distinguished panelist, learned panelist, is talking about justice. Is this justice that a woman would be left high and dry? Even when we go out of the house, we tell her.
Is it justice if a woman who is an Indian citizen protected by the Indian Constitution is being left high and dry because her husband, without informing her, brings in a second wife, a third wife, or a fourth wife? Well, the Kerala High Court has made it very categorically clear that when it comes to constitutional rights are supreme to anything that the religion permits. Dr. Zeenat Shaukat Ali, thank you so much for joining us. Ahmed Ayaz as well. Unfortunately, we are out of time, but this debate continues. Haq is the movie which has actually sparked off a massive political storm all across the nation. We leave you with that, a short break.